submissions. The doctrine is anchored in Article 73(1) and Article 1. Article 1 of the Constitution talks and says like this: mamlaka yote makuu ni ya wananchi wa Kenya na wanaweza kutekeleza tu kulingana na katiba hii. Mamlaka ya wananchi katika katiba hii yamepewa idara zifuatazo za serikali. My lords, there is a clear delimitation of who serikal is and who mwananchi is. My lords, I also invite you to look at the erroneous application of Article 35 of the Constitution together with unreasonable and reliance of the affidavit of the Auditor General at paragraphs 47 and 48 of our submissions, pages 47 to 48 of our submissions. And therefore, in conclusion, my lords and my ladies, with such demonstrable disingenuity, should the court fold its hands under the doctrines enunciated here of political ripeness, mootness, political questions, I am afraid that the liberties of Kenyans and inalienable rights of the ordinary mwananchi would be suspended by a thread so slender than the hair strand that held the sword of the imperial King Dionysius over the head of Damocles. Thank you.
Council, do your best to stick to the time.
My Lord, I will request for 5 more minutes. And by introduction, my name is
You will have to stick to the time, Council. We really are very, very pressed for time. I wish you could start.
I'll try, my Lord. My Lord, my name is Topuale Cinco for the purpose of the record.
Okwale?
Topuale Cinco. And just before, my Lord, I proceed with my submission, I just want to make a rebuttal on what Senior Counsel Kamau Karori said regarding the interplay of Article 38 vis-a-vis Article 257. My Lord, the argument by the appellants is that the President is entitled to initiate a referendum on the guise that under Article 38, which provides for political rights, the President has a right to champion the cause. And I think Justice Kiage followed that. What really happens when the Parliament is wrong? My Lord, my submission is that there are enough safeguards that provides the President with avenue for lawmaking. And just to cite maybe one, under Article 261, my Lord, the President can actually have the Parliament dissolved if it's not performing its function. And under Article 1.4, the people can actually, my Lord, recall their representative where they are not providing or rather carrying out their mandate. And therefore, that is not a justification to abrogate the President the power to amend laws under Article 257. My Lord, the basis also for Article 257, which gives the ordinary mwananchi the right to amend the Constitution, comes from Article 1. The reading of Article 1, my Lord, and this is actually factored also through the history of the Constitutional Review Commission and the final report. Under Article 61, the Attorney General, my Lords, have considered to the fact that the question of amendment has never been contentious in all history making of, in the constitutional history making of Kenya. Therefore, the people of Kenya had a very clear mind that they intend to undo that power that enabled the rogue executive parliament to mutilate the Constitution. There was therefore no hard time, my Lord, to try to balance rigidity and flexibility to amend the Constitution. And that it's my submission that the powers that the legislature, the executive, my Lords, enjoy is derived from the Constitution. And when you consider like chapter 18, page 18, sorry, of the Njoya case, Justice Ringera talks about the constituent power being primordial. that over and above the constituent power, my lord, being derived, it is also regional. That has to, it's two-pronged, my lord, that the people are bound by the constitution, but also the constituent power is original. And that actually takes us to a definition that in some instances that the people might not be bound by the constitution. Any interpretation, my lord, therefore, that says that the president is not entitled to initiate amendment of the constitution through popular initiative, my lord, I think will be the correct interpretation in that the people are the sovereign. They are the one who donated and constituted the legislature, the executive, and the executive can only act, my lord, within the limit of the power that the people have donated. If the president, my lord, therefore wants to amend the constitution, and if it's indeed in the interest of the monarchy, the president, my lord, can actually resign and do that in his private capacity as a citizen. And I will direct you, my lord.
Mr. Siko, the point was well made. Please move on to the other one. You have 2 minutes precisely.
My lord, I'll just direct you to a decision by Justice Nambuye between the Ethics and Anti-Corruption Commission versus County Government of Meru, where it was held that in the regime of the Bill of Rights.
Which decision?
Ethics and Anti-Corruption Commission, my lord,
okay,
versus Think County Government of Meru 2018.
All right.
Justice Nambuye and retired Justice Philip Waki presided over that. And it introduced a dichotomy where you view the state, my lord, as a duty bearer and not the right holder. Therefore, the argument, therefore, that you can actually limit the right of the president to express his political rights for the interest of the local monarchy, my lord, actually survives. My lord, as I conclude, I just want to point out what Dr. Viankolu left in the interest of time on the issue of political question doctrine. And our submission is that in as long as it is the interpretation of this court that the popular initiative is an individual right, then the political question doctrine should not arise. I will direct you, my lord, to abundance of authority, the case of R. vs. Miller, concluded by the Supreme Court of the UK, and also the case of Becker vs. Carr. Justice Brennan, my lord, in that decision, brings out a distinction that whenever power is clearly delineated between each arm of the government, such that when we are arguing about the executive, there's a clear line that their mandate is to do with things to do foreign relations, defense. The argument, therefore, that one has abrogated the power of the other, my lord, should not arise. And also, we provided an article by Professor Louis Henking, arguing that the political question doctrine is actually applicable in America and is an disingenuous legal mechanic to shirk off judicial responsibility. The Superior Court, my lord, has unlimited and original jurisdiction under Article 165 to interpret, my lord, the Constitution, to promote in the interest of the local monarchy, and that power is rightly delegated by the people under Article 1.
Thank you, Mr. Siko. Thank you very much.
Thank you, my lord.
Thank you. Senior Counsel Karua, are you here? Sorry, Hamino. Please, can you take your 30 minutes right now?
With the court's permission, there is a young lady counsel, Caroline Kituko,
the one who was to appear online, virtually?
She's here now, and she's requesting to be heard first. Her condition does give her to request the court to be heard first.
Before?
Yeah, she thinks too much sitting may affect her condition.
I see.
I would request
Dr. Amino, did you hear what Senior Counsel Karua said about Ms. Kituku, that condition cannot allow her to sit down for long. She would like to make a short presentation. Before you do...
I didn't hear my Lord, but I will return as well.
All right.
Thank you.
Unless you want to do it seated. Do you want to sit down?
No, my Lord, I'm fine standing.
You're fine standing. Okay. Please introduce yourself for record purposes. And you need, I think, 10 minutes would do.
No, my Lord, I represent a main party, the respondent, Muhuri, Muslims for Human Rights, who was the main petitioner in petition E2 of 2021 in the High Court. So we'll be seeking to have 45 minutes.
We were calling you yesterday. You could not connect virtually.
My apologies for that.
We will give you a maximum of 30 minutes. We know you are that was the main petitioner. So go ahead right now.
Thank you, my Lord. So the President of the Court and the Honorable Justices, my name is Caroline Kituku. I appear together with Mr. Muhuyu Mwaniki from Muhuri, the 26th respondent in the IBC appeal. We oppose the appeal, and we have filed grounds of affirmation dated the 23rd of June 2021 that we're seeking the court to affirm the High Court judgment. We have also filed the submissions dated the 23rd of June 2021. My Lord, Muhuri's case seeks to challenge the actions of the IBC to process the BBI bill in violation of the Constitution. Muhuri submits that the actions of the IBC to receive the draft amendment bill, that is a BBI bill, together with the supporting signatures, and proceed to verify that the initiative was indeed supported by 1 million registered voters, and certify the bill and forward the same to the County Assembly. The IBC acted in violation of the Constitution, and in particular, Sections 10, Section 94, Section 82(2), Section 249, as well as Article 257, 4, and 5. We say so because at the time the BBI amendment bill was received by the IBC, IBC could not properly, lawfully, and satisfactorily discharge its mandate under Article 257(4) of the Constitution because it lacked the sufficient legal and regulatory framework to process the draft amendment bill. Therefore, it could not proceed to verify that the bill was indeed supported by 1 million registered voters and certify it as such and forward to the county assemblies. To that extent, therefore, I shall address the court on 3 aspects. The first question is whether or not IBC required a legal framework to guide it undertake its mandate under Article 257, 4, and 5. The second question would be whether or not such a regulatory framework existed as at the date the IBC received the BBI bill. And finally, the question of whether or not the procedures that the IBC used were indeed lawful, to the extent that they could help and guide IBC in the verification and the certification process. Now to the first question. whether or not the IBC required a legal and regulatory framework. It is a submission that the IBC required a framework to guide it undertake its mandate under Article 254. The High Court agreed with that submission and found that at the time that the IBC received the BBI amendment bill, it required to have a form of a legal and regulatory framework to guide its work. You will find that finding at paragraph 752 of the High Court judgment. We therefore urge the court to affirm that finding for the following reasons. Number one, Article 82(1) of the Constitution mandates Parliament to enact a legislation to provide for the conduct of referenda as well as elections in this country. It is therefore the obligation of Parliament to ensure that there is a law in existence that would seek to guide the processes that are associated with the referenda in this country. My lord, my ladies, there are many authorities from this court and as well as from the Supreme Court that hold that an election is not a one-day event, it's a process. Applying the same reasoning in this matter, we would urge this court to find as much that a referenda is not a one-day event, it's equally a process that starts right at the time a promoter comes up with the idea to amend the Constitution, to the point of collecting signatures, to the point of taking them to IBC, to the point the IBC verifies them, certifies them, takes them to the county assemblies, takes them to Parliament, and eventually to the referendum and the counting and the declaration of the referendum result. It cannot therefore be that the law that IBC seeks to rely on, that only provides on the conduct of the referendum, is the sufficient law. There is no law at all that provides for the verification and certification processes under Article 257(4) of the Constitution. Such a law has not been provided in this court because it does not exist and it is not there. The law that this court was referred to exists in section 49 to 55 of the Elections Act. My lord, my ladies, a careful reading of that law will show that it does not in any of its provisions provide for the procedures on the correction and verification of signatures, on the procedures for certification, and on the procedures that are supposed to be undertaken by IBC insofar as its mandate under Article 257(4) and 5 are concerned. My lord, conscious of all the processes that are required to give effect to the referendum, the Constitution has therefore mandated Parliament to enact the law, to regulate those processes. And the reason for this is not difficult to find. It is because each of the processes that are required in the context of a referendum, and in particular Article 257(4), right from the point of collecting signatures to the declaration of the referendum results, if at all, are important, they are fundamental in a democratic society. It cannot therefore be true that Article 257(4) and 5 is self-executing, as this court was told by the IBC. How does it execute itself? Well, it does not have any procedures or any provisions on how signatures are supposed to be collected, verified, and certified. My Lord, having said so, the next thing we need to consider is the mandate that the promoters of a popular initiative have under Article 257(4). The obligation is to deliver the draft bill and the supporting signatures to the IBC in order for the IBC to be able to verify indeed that the draft bill and the proposals therein are supported by 1 million registered voters. The question therefore is, what is the role of the IBC upon receiving the draft bill and the supporting signatures? The High Court, at paragraph 734 of its judgment to 741, set out in detail what the IBC is required to do in order to give effect to the provisions of Article 257(4) and 5. The first thing the court said, which we seek to have this court affirm, is that the IBC must verify that the bill to amend the Constitution through a popular initiative is indeed supported by at least 1 million registered voters. My Lord, my ladies, it is a summation that IBC indeed understood its mandate to that extent very well. To that extent, I therefore refer the court to the record at page 3202 to page 3208.
Yes, continue.
Page 3202 to 3208. The record clearly indicates and provides evidence from the IBC itself. IBC in those pages, especially starting at page 320, came up with what it is calling the budget for signature verification. At page 3203, when it came up with a budget, it funded it to the National Treasury. At page 3203 of the record, we will find a document in form of a letter dated the 16th of December 2020 from the Cabinet Secretary, National Treasury and Planning. Paragraph 2 of that document clearly authorizes IBC to go ahead and spend some 93 million thereabout in the process and in order to undertake verification of signatures following the draft bill and the receipt of those signatures by the promoters of the draft bill, being the Building Bridges Initiative. All the way to paragraph 30, page 3205, the IBC itself acknowledges that it has a role to verify that indeed the signatures that have been presented to it are the ones that support the initiative. At page 3206 of the record, you will find a document from the IBC that seeks to make announcement for vacant positions for persons who are going to undertake the verification of signatures work at the IBC. It called members of the public to apply for that job, and it listed the criteria that it was seeking from those people. At page 3207, you will find a tweet from the Twitter handle from the IBC that informs members of the public that indeed IBC has started its verification processes of the signatures that it received in support of the BBI bill. Finally, at page 3308, you will find a document that is known as the Administrative Procedures for the verification of signatures in support of a constitutional amendment referendum. All around, and all those documents demonstrate one thing, that what the IBC sought to do was to verify the signatures that were submitted to it in support of the draft amendment bill. To that extent, therefore, we submit that for IBC to have been able to do that particular mandate constitutionally, it required some form of a regulatory framework to enable it to undertake that important constitutional obligation. My lord, my ladies, Mr. Ngumbo informed and submitted in this court that Article 257(4) has 3 aspects. He referred to the aspect of the first one being an initiative, the second being verification, and the third being supported by 1 million registered voters. My lord, my lady, we submit that he conveniently and properly sought to misguide the court by omitting the 4th aspect, which is a draft bill that is supported, the draft bill and supporting signatures. There cannot be an initiative, it cannot be an initiative without a draft bill and its supporting signatures. A careful reading, or a plain reading actually, of Article 257(4) indicates that a promoter of a popular initiative cannot deliver the draft bill to IBC without the supporting signatures. So what is then the purpose of the supporting signatures? Or rather, put differently, why did the Constitution deem it important that for a promoter who intends to amend the Constitution must collect supporting signatures and have them delivered to IBC and not DCI? What then was the intention behind that provision in the Constitution? Mr. Ngumbo made this court believe that the supporting signatures are not useful at all. In our view, it could not have been the intention of the drafters of the Constitution to have the signature requirement for cosmetic purposes. No. Had the Constitution envisaged that the IBC should use those other unique identifiers, as Mr. Ngumbo told this court, then nothing, my lords and my ladies, would have been easier than the Constitution to say so. To that extent, therefore, I seek to rely on paragraph 12J of the affidavit of Mr. Michael Ngoa, Michael Ngoa, at paragraph 12J of his affidavit, in opposing the petition before the High Court and in support of the IBC case, stated that a signature is just one of the unique identifiers that IBC can use to verify whether or not a supporter of the initiative is a registered voter. He states that IBC has other identifiers which are unique to IBC, such as a surname, for example, an ID number, the sex of the registered voter, the date of birth, and so on. Then the question is, why didn't the Constitution use any of these unique identifiers in order to identify, indeed, that the registered voter is the one who is supporting the initiative? I submit that there was a reason why the Constitution uses signatures, and that reason cannot be overlooked by this court or by the IBC. Mr. Ngumbo further informed this court that by requiring IBC to verify signatures, we are basically requesting the IBC to undertake forensic analysis and work that is a preserve of the DCI. My Lord, my ladies, that summation is incorrect. We say so because Michael Ngoa's affidavit as well, at page 3287, that is paragraph 12K, paragraph 12K, it states that in respect of every registered voter, IBC has a record of all Form A's which contain the signature or thumbprint of a voter, the constituency of that voter, the county that voter comes from, the ward that voters come from, and so on. Therefore, it cannot be that IBC, where it says that it keeps Form A, which has all these details about a voter, including the signature of the thumbprint, can now purport to say that it does not have a means to verify the signatures, whereas it does hold those signatures. The question then is, do we need DCI to undertake a forensic analysis? We submit no. An analogy would be made. Every bank, if you have an account in any bank in this country, the bank has your signature. How does the bank verify that signature without having to undertake a forensic analysis from the DCI, as Mr. Ngumbo makes us want to believe? In addition to that, at page 3217, at page 3217 of the record, you will find a form produced by IBC in opposing Muhuri's petition. The form is titled Form for Collection of Supporters' Details and Signatures. The IBC envisaged and actually did create a format through which a promoter of a popular initiative would use to go out there and collect signatures. What are these signatures for that it intended, and what are they to do with them if they did not have an obligation to verify them upon receiving the signatures? Further, my Lord, I refer you to paragraph 12O of the affidavit of Michael Ngoa, where it states that the responsibility of the IBC after verifying, it states so. It's not our evidence, it is IBC's evidence. The responsibility of the IBC after verifying signatures is to send the verified signatures to the promoters and public for confirmation that indeed they gave their signatures in support. So the question at this point is, did IBC do so? Did IBC at any point verify the signatures? Did it send them back to the public for verification? To answer that question, I refer the court to page 3340. Page 3340 of the record, where you will find a document called Notice of Interim Verified List of BBI Supporters. At paragraph 2 of that notice, the IBC states, it undertook data cleaning exercise by removing incomplete records. That is, I'm quoting verbatim, that is, missing signatures, ID numbers and names, duplicates, and those not in the registered voters. What IBC then tells us, the members of the public, it did was to do a cleaning exercise. It undertook a data cleaning exercise as opposed to verifying the signatures. It never came out to provide a list that had proper supporters and their signatures that it had verified. What it did, it used again the unique identifiers in the list that it sought to upload in its website.
Council, you have 5 minutes to go.
Further on that issue, we submit that until now, the position of the IBC on this process is not known. I say so because Mr. Ngumbo told this court that IBC could not verify the signatures, but on further cross-examination or rather questioning by the member of the bench, Justice Honorable Kiage, he stated that IBC verified. The question therefore is, what did IBC do? It is not known, it is unknown, and that's why its actions are not accountable to anyone or any person. Mr. Ngumbo further informed this court that IBC did not have a database of signatures. Indeed, that evidence is also on record, and I refer you to page 3197 of the record, where you will find a letter by the IBC to Muhuri confirming that indeed it did not have a database of signatures. But all this contradicts IBC position, and it does so because it states, first of all, it has a Form A in its custody. The Form A apparently has the signatures of every registered voter. It further goes and informs my client that it does not have a database. So the position until now of the IBC cannot be ascertained, not by this court, not by any other independent person, because whatever it did to do was not accountable and was not in any way verifiable. On that issue again, Mr. Ngumbo gave an analogy to this court. He told this court a few days ago, Kenyans were able to complain to the registrar of political parties that they had been registered without their consent as members of various political parties in this country. Why were Kenyans able to make that public outcry? They were able to do so because the registrar of political parties maintains a system that is verifiable, simple, transparent, and credible. All that a Kenyan citizen needed to do was to go to e-citizen platform, input their ID number, and have the details of whether or not they're registered as a member of a political party. Can the same process be said of the IBC and in the manner in which it is sought to conduct its mandate under Article 257(4)? We answer no. IBC did not have a simple, accessible, and verifiable process that it could have used in relation to satisfy that indeed the initiative was supported by more than 1 million registered voters. Finally, before I log off, I would like to refer this court to the administrative procedures that apparently the IBC said it used. The IBC, in its own administrative procedures, and those procedures you'll find them at page 3208 to 3216 of the record, it states step by step what it is sought to do and how it is sought to do it. From paragraph J, it states step by step on verification of signatures, getting budgetary allocation, going to verify both the print and the soft copy of the signatures. It states clearly what it was supposed to do, but it did follow its own procedures. It did not. What it did was to do a data cleaning exercise. We therefore urge this court to affirm the High Court findings that the IBC, in the manner in which it carried out its mandate under Article 257(4), violated the Constitution as well as its own procedures that it had developed to assist the court.
Thank you very much, Counsel.
Thank you, my Lord, and I will seek, because I could not cover everything that I intended to refer the court to submissions.
Yes,
and I
thank you
believe
very
that
much.
they'll do so. Thank you very much.
Thank you. Senior Hanzo Ameno.
Permit me to say good morning, my Lord.
Good morning, Dr. Ameno.
Yeah. My Lord, may I say I'm very proud and very happy to have the privilege of appearing before your Lordships. My Lord, before I go on, Justice Musinga, President of the Court of Appeal, we thank you very much for the efforts you have taken to put us in very civilized surroundings. I know what it means to have had to put up such a structure at a very short notice. We remain most grateful to you.
Thank you.
My Lord, may I take this opportunity to congratulate my Lady Justice Okwengu. Lady Justice Okwengu, may I say to you, we remain proud of you. I have had the privilege of appearing before you since the days you were magistrate, a High Court judge, and Court of Appeal. Some of us who have known you for a long time will remain most proud of you, and I convey to you my sincere congratulations and wish you very well. My Lord Justice Tuyot, I equally congratulate you for having been elevated to the Court of Appeal. It was always a pleasure to appear before you when you are High Court judge. I always looked forward to the time I'm going to appear before you, and I was happy with the points you used to raise, questions you used to ask me, to interrogate me, and I look forward to continuing to appear before you. I wish you very well on the bench. My Lords, may I say one or two things? The President of the Republic of Kenya, the Honorable Mr. Justice, the Honorable Uhuru Kenyatta, has filed an application, and I'm inviting you very respectfully, my Lords, that you do not take note of the application that he has made before you at all. My Lord, while he was at Kisumu, he made certain remarks about judges. My Lord, he has failed to get 2 judges who are involved in this case in the High Court to be sworn in as Court of Appeal judges. That is Justice Udunga and his colleague who have not been sworn in at all. My lords, when you come to the court, you must come with clean hands. The President has not come to this court with clean hands at all. And I'm humbly urging you that you borrow a leaf from South Africa. You borrow a leaf from India and Pakistan and say to him, no, we shall not hear you. The orders that were made by the Court of Appeal must stand. He has deliberately refused to swear in judges. My lords, it's my humble submission that when you are coming before a court, you cannot despise a judge and at the same time you appear before a judge and you expect that judge to give you orders at all. May I say, my lords, when you appear before your lordships, we come with tremendous humility. We speak politely to you. We praise you. That praising, that humility, and that courtesy that we extend to the court is not for you personally. It's for the good of the entire country of Kenya, to get our people to continue to have confidence in the judiciary and in the administration of justice in our country. And when you have a president who is not obeying court orders, when you have a president who is demeaning judges before the public, this court must stand firm and say to him, no, we shall not hear you. We shall not give you orders at all. Again, I respectfully urge you, you borrow a leaf from India. You borrow a leaf from Pakistan. You borrow a leaf from South Africa. Decline respectfully and say to him, we shall not hear you, and whatever complaints you have, raise those complaints before another court, but not this court at all. My lords, the 2010 Constitution, perhaps before I go on with that, I have made a list, my lords, which I may give you the I have made a list of some authorities or some books I have, which I know that your lordship may not be having them. And I would be prepared to list them to the court through the registrar if that would be. My lords, I have included them in a list of authorities here. If you may permit me to hand them to you.
But be mindful about your time, eh?
No, I know, my lords, as usual, you'll be kind to me.
No, not today, Dr. Haminwa, Senior Counsel. You have precisely 23 minutes now remaining.
Yes. My lords, the books I have are on constitutional amendments by Yaniv Rosnai, Constitutional and Political Theory by Ernest Wolfgang, a constitutional judge of Germany, Making Constitutions in Deeply Divided Society by Hannah Lerner, Constitutional Amendments by Richard Albert, and an amendable Constitution by Richard Albert Batil Emra, The Foundations and Constitutions of Constitutional Amendments. There is one book I have not brought to the court, but I'll make it available if the registrar asks me. It's called The Theory of Imperfections. in constitutional making and constitutional amendments.
Yes.
My lords, the Constitution of Kenya 2010 was a response to two things: to the rotten history of this country,
Yes.
and to development of international jurisprudence or global jurisprudence. My lords, those of you who are young may not know that this country has a rotten history. This is set out in two books. One is Kenya, A History Since the Independence, by Professor Charles Hornsby, Professor of International History, I think, at the University in Australia. The other one is Kenya, Between Hope and Despair, by Daniel Branch. My lords, Condoleezza Rice, who is now, I believe, a professor at Stanford University, when she was security advisor to President George Bush, in her new book that has come out, Democracy, Condoleezza Rice, at page 127, there is only one sentence, my lords, which I would like to read to you. At page 217. On Inauguration Day, he, that's our President Mike Kibaki, told Kenyans that he was inheriting a country badly ravaged by years of misrule and ineptitude. That was a correct statement. There were assassinations in the country. Pinto, J.M. Kariuki, Tom Mboya, William Ouko, and etc. Many assassinations. People died in suspicious circumstances. Some left the country in exile. People like Ngugi wa Thiong'o, Mazurui, they left the country. There was rampant corruption in the country. My lords, the Constitution, the 20th Constitution, was intended to take care of this. The judiciary was not spared. There was no security for judges at all. Some judges, some judicial officers died under suspicious circumstances. These were things that the new Constitution was supposed to take care of. And my lords, if you read the Constitution very carefully, the way I do, you will find that it does take care of certain things. Certain officers are entrenched. The office of the DPP, the office of the Inspector General, the judiciary, devolution, the preamble, the sovereignty of the people, the leadership code, and etc. My lords, all these things were included in the 2010 Constitution to send a message to Kenyans and the whole world: never again shall we go through this kind of life. Never again shall we go through this. The way the Japanese Constitution has a provision to the effect that never again shall we have war. The way the Caribbean in the Constitution has a provision, never again shall we go to capitalism. We say to the whole world that never again shall Kenya have this kind of life. And my Lord, this is repeated in the Constitution. If I may refer you to Article 255 of our Constitution, dealing with amendments, 255. My Lord, if you read 255, 256, and I believe, yes, 255, 256, and 257, it emerges very clearly, my lords, that this Constitution is unamendable. This Constitution is unamendable. And it is not surprising, my lords, that in one of the books, sorry, my lords, we are not as organized as we should be when you are appearing before the Court of Appeal. My lords, if you go through this book I refer to, unconstitutional constitutional amendments, unconstitutional and constitutional amendments, my lords, if you look at page this is page 236, my lords. Page 236 to page 274. 236 to page 274. Yanim Rosnai, in his thesis for London School of Economics, he has a heading, Explicit Substantive Unamendability of World Constitutions. Explicit Substantive Unamendability of World Constitutions. My lords, he has set out all the countries that have unamendable war constitutions. And Kenya is one of them. Kenya is one of them. My lords, Kenya is one of them, and I'll read to you at page 258. Page 258. He has set out very clearly that Kenya is one of the countries that has an amendable constitution. And he quotes paragraph, articles 255.
Would you kindly speak to the microphone?
Oh, sorry, my lord. Yeah. Paragraph 255 to article 257. Paragraph 255, article 255 to article 257 as unamendable. And the reason he gives different procedures for different provisions, different procedures for different provisions, different provisions for different procedures. And indeed, my lords, when you will look at these articles, when you are writing the judgment, articles 255, 256, 257, you will find they have different procedures for amendments. When you apply them, it's difficult, impossible to carry out effective application. It is cumbersome. It is onerous. You cannot actually carry out into practical terms these provisions at all. My lords, it's my humble submission that one contribution that this court should make to the able judgment that was delivered by our 5 judges, that is Justice Ngugi, Justice Odunga, Justice Teresa Matheka, Justice Mwita, and Justice Jairus Nga, is for you to strengthen that judgment by making a firm finding or a firm order that the Constitution we have now, the 20th Constitution, is unamendable. My lords, that is not wrong. You will be protecting democratic values of the country. To have at the moment a constitution that is unamendable, you are protecting democratic values of the country. There are some people in this country who would like to take us to the old days. We must say to them, no, you will not. We have an unamendable constitution. And an unamendable constitution, there is nothing wrong with that because it is protecting democratic values. My lords, constitutions of the world, whole world, the global kind of development of jurisprudence is towards having constitutions that protect democratic values. And this has been summed up in these 2 books, my lords. My lords, I refer to the books called Constitutions of the World. I believe you must be having a set. There are 4 volumes. They are produced by the Indian jurist M.V. Paile, Constitution of the World. And you find that these constitutions have communality, separation of powers, the role of the judiciary, the role of the executive, the role of parliament, and they have entrenched provisions in all these constitutions. My lord, there was an attack on India about basic structures. May I deal with that? My lord, India has been on the forefront in jurisprudence or international jurisprudence. My lord, you may remember Bangalore principles which were brought about by Chief Justice Bhagwati. India is a member of the Commonwealth. We are members of the Commonwealth. What happens in India, we cannot afford to ignore it. We apply Indian authorities from time to time in our courts, and we cannot say something trying to despise India or trying to show that India is different from us. My lord, with complete respect to my learned friends who said that, that is completely nonsensical. We ourselves have a lot in common in India. India is, as it were, our sister country. We have a significant population of Indian origin in this country who continue to make a significant contribution to the development of this country. So what happens in India is of considerable importance to us as a country. Now, my lords, if you take the basic doctrine, you'll find that it has spread to many countries. It has spread in Asia. It has spread in Africa. It has spread to Caribbean. It is a part of the global development of global jurisprudence development. It is what you can call part of international jurisprudence. Perhaps I should also add, my lords, that we had a very good meeting also in India of lawyers, including judges, and this book was produced of challenges to the legal profession and investment in developing countries. Again, this was in India. Now, the basic doctrine, my lords, can be taken to be part of the definition of the word amendment, which you will find in the New Oxford English Dictionary. Yeah. And my lords, I've just been advised by Valentine Kaminwa that the word amendment has to be, is in singular, is not in plural at all. My lords, I have filed submissions, written submissions. I hope you have got this book, one that is dated, this one. Which one is this one? Yes, we filed submissions, my lords, on 23rd for Kenya Human Rights Commission. They should be there. We filed submissions, Kituo cha Sheria, on 24th June. They should be there. My lords, may I say this?
In 5 minutes, please.
Yeah, I'll take a short time, my lords. I don't intend to take much more time than that. May I say this, my lords? My learned friends who appeared for the appellant, I listened to them very carefully, and I thought that some of them, whom I happen to know very well, who are great friends of mine, very close to me, and I talked to them from time to time. I got the impression that some of the things that they were submitting to your lordships, they are not things that they really stand for.
They are not what?
Things that they stand for. I happen to know them. Yeah, I thought that they were saying to you things that they themselves don't seem to believe in at all. I happen to know them. Some of them are great friends of mine. I eat with them. I take cups of tea with them, and I know what they stand for, and I thought that when they were addressing your lordships, they were not saying things that they themselves believe in at all. My lord, as a country, we have been unfortunate, very, very unfortunate. We have not had what I can term as selfless politicians at all. The crop of our politicians in this country is very poor. Most of them are job seekers.
The microphone for record.
Yeah. Most of them are job seekers. They stand absolutely for nothing. And you can see even when they are campaigning, they do not tell anybody what they would do when they come into power. One gets the impression that all that they are doing is looking for a political office. The nearest politician or politician selfless for the years I've been in Kenya, the nearest we have is the late Professor Wangari Maathai. I served him as his advocate. I appeared for him in court. This was a great lady. She was selfless in many respects. And the other two, I would say, or what the other one I would mention, my Lord, is a self or selfless, is Kenneth Matiba. My Lord, the first group of politicians who brought us Uhuru in this country was selfless. But after that, the politicians who come into power are tribalists. Most of them are tribalists. They are advancing tribal agenda. My Lord, what they stand for is really to see that they come into power. And the problems they have are their own personal problems. We have to appreciate that the law has got limits, its own limits. Professor Allott tells us so. The Constitution has got limits. That's what we learn from constitutional jurisprudence. And whatever problems we have in this country have absolutely nothing to do with the Constitution. They have nothing to do with the law. They have something to do with ourselves, and particularly the political class. When it comes to violence, they are the ones who are actually, one can suspect, they are really the ones who are fueling this violence. This is set out in the book of
You have a few seconds, Dr. Amino, please.
Yeah, my Lord, may I draw your attention to Interrogating Marginalized Governance by editor Professor George Garner from our university. That is the book I had in mind that I would like to draw your attention to. My Lord, may I say thank you very much.
Thank you.
I urge you very respectfully, you throw out the appeal. It has no merit. Absolutely none. The submissions that were made before you were pedestrian submissions. Were not in good faith. Instead, my lords, I'm inviting you respectfully, you uphold the judgment of the High Court and you improve on it.
Thank you. Thank you.
Thank you very much.
Thank you, Senior Counsel. Can we have Senior Counsel Martha Karu? Yes.
May it please the court, I'm Martha Karua, appearing with Muthoni Nyuguto for 3 amici, that is Dr. Ojwang, Duncan Ojwang, Dr. Linda Musumba, and Dr. John Osogo Ambani. I propose to use 20 minutes, seek extension if necessary, and leave 10 minutes to my learned junior, Muthoni Nyuguto. The documents we have filed are written submissions dated the 22nd of June this year with 2 annexures. Digest of authorities dated the 22nd of June this year. Bundle of authorities dated 22nd June this year. All 3 bound in green. 4 proposed amici brief adopted by High Court, which appears on page 1072 of the AG's record, volume 3. Finally, written submissions dated 9th March this year with 2 annexures appearing at page 1016 in volume 3 of the AG's record. Those are our documents. If
Thank
it
you.
may please the court, constitutions exist to limit the exercise of authority. And this does not appear to be understood or taken into consideration by the executive in Kenya, and indeed by many state entities and state officers. And it is clear to me that modern dictators, especially in Africa, are using the Constitution or constitutional amendments as a special purpose vehicle to claw away on civil liberties and democratic gains. And we have examples all around us, even in the sub-region, where extension of presidential terms through constitutional amendments have been happening. The point I'm making, my lords, is that while pretending to observe the Constitution, the political elite will use amendments and constitutional amendments to ensure that they extend their stay in power and concentrate power in their hands. It is our humble submission that this is a consideration that this court ought to put in mind when evaluating this case. The Constitution of Kenya 2010 recognized the danger of this behavior by the political elite. And if you look at the history, which is the CKRC report attached to the Attorney General's record and has been cited page 74 to 76, you will see the fears Kenyans had in the making of the Constitution, that the political elite would mess with the 2010 Constitution much more the way they had messed with the Independence Constitution through hyper amendments. This history is important in evaluating what is happening. When my learned friend, Mr. Senior Counsel Orengo and Senior Counsel Amolo were here, they were happy to state they were part of the constitutional review. I would like to say that I have lived that history too. Throughout the formal process, the more than 20 years of search for the Constitution, and during the tail end, as a member of the Parliamentary Select Committee with my learned, my friend Senior Counsel Orengo, and part of that time as the Minister of Justice. And I want to refer the court to the Constitution of Kenya Review Act, 2008, revised in 2009, and in particular to Section 23, which spells out the function of the committee, to Section 31, before 31 to Section 29, which says what materials the committee would use. And why I'm doing this, because the court has been told that the Constitution of Kenya 2010 is a political settlement. It's quite clear from the mandate given to the Committee of Experts in that act. What the Committee of Experts was doing was to rely on all the documents, all the views given by Kenyans, and to resolve the contentious issues, and to ensure that the review process faithfully reflected the will of Kenyans. So when we are told that it's a political settlement, far from it. It actually reflects the will of Kenyans, and yes, there were political settlements in Naivasha. And those settlements related to the system of government, to the form of devolution. I'll mainly talk of those two and say that even in resolving the political system, as part of the group in Naivasha, we did not go beyond the suggestions given to the committee of experts. We just picked the presidential system from among the three options: hybrid, parliamentary, presidential. So even that was not far from the wishes of the people. And I know that the political party I lead and several others had actually presented to the COE for a presidential system. So even that choice was influenced by the views of Kenyans. It was not merely the wish of politicians. And devolution, having picked the presidential system, we adopted it to our situation to be devolution in a unitary system. So what I'm saying is that this is a process reflecting the dreams and aspirations of Kenyans as stated in the preamble of the Constitution. My Lords, in the 2010 Constitution, the judiciary in Article 1 and Article 159, judicial authority must be exercised for the purposes and principles in the Constitution and shall be protected and promoted. And judicial authority must be guided by the principle that justice shall be done to all irrespective of status. This again is anchored in the Bill of Rights, Article 27, which clearly states that everyone is entitled to equal protection and equal benefit of the law. I'm emphasizing that, my Lords. I know you know it, but it is important that we remind all of us that nobody should come to this court with a sense of entitlement, however mighty. Once you enter the doors of the court, you are a litigant just like any other. We are therefore asking the court to ignore all statements that have been made extraneously, some of them predicting the outcome of this case, sounding very much like a team member in a boxing match shouting to the opponent that they've already won before the match has started. We urge the court to take its time to read the submissions and the authorities cited and the proceedings of the Superior Court, and to see that the Superior Court discharged its judicial duties admirably in a well-reasoned judgment and gave declarations pursuant to its powers to interpret the Constitution. It was suggested that before by the appellants that the Superior Court or the High Court cannot give advisory, only the Supreme Court. We have no quarrel with that. The High Court did not give advisory. It made declarations as it's entitled to do. This was a suit seeking declaratory judgment, and the court pronounced itself as required and as it is entitled under the law. My Lords, my ladies, I submit that we are yet to fully implement our 2010 Constitution. It's a work in progress. And Kenyans, knowing that the political class may be a hindrance, and indeed it has been to the faithful implementation of the Constitution, gave to the court powers not only to interpret, but under Article 165, to determine whether anything said or done under the Constitution is constitutional. That is what the High Court was asked to determine under 165, and all they did was to discharge their duties. We urge you, in reviewing the evidence, to come to the same conclusion and to find that the High Court, the judgment before you, is safeguarding the dreams and aspirations of Kenyans. And indeed, it is the duty of this court as the guardian of the Constitution, or the duty of the courts as the guardian of the Constitution, to ensure that it sets beacons, it sets limits as demanded by the Constitution of the exercise of authority, not of judicial, but of authority by the political elite. I want to say that this court's powers are not inferior to those of the executive. All the arms of government derive their power from the people. And this court has the final word on the interpretation of the Constitution. Drawing on my learned Junior Mudhomi's analogy yesterday, we invite the court to use its sword to mark the beacons of exercise of power by the executive, and to find that the judgment of the High Court should be upheld and the appeal dismissed. Coming now to the question of the attack on the role of the amici in the High Court, which is ground number 6 of the Attorney General's appeal. We submit that the amici discharged their role of advising the court, of assisting the court, of maintaining fidelity to the law, of being impartial, and this is shown in the submissions of the amici before the High Court, which are on page 1019 of the Attorney General's Record of Appeal, and also the submissions by our clients before this court, which are already before you. We were cited as respondents and therefore came to court as such. But the sum total of our submissions will show fidelity to the law, impartiality, the fact that part of our submissions may coincide with the submissions of parties. That does not make the amici biased per se. The amici are talking of the law as it is and assisting the court mainly to understand the basic structure. And coming to that, my lords, my ladies, our submission is that the basic structure is inherent. It is part of the DNA of any constitution. Whether it has been designed or not, as a matter of fact, every constitution has a basic structure. Ours is no different. And if you look at Article 255, you will see protected clauses, which we submit are part of the basic structure of the Kenyan Constitution 2010. We ask you to be persuaded, like the High Court was, that indeed 2010 Constitution has a basic structure and that the basic structure doctrine is applicable to Kenya. My lords,
yes.
the implementation or the realization of the dreams and aspirations of Kenyans depend on the courts as guardians of the Constitution. It is through pronouncements of the court, without fear or favor, that this country will eventually achieve the transformation envisaged by the 2010 Constitution. We invite you to rise up to your duty, and in Dr. Mudhomi's words, to utilize the sword to slay the monster. And the monster, I dare say, is the monster of impunity, of self-entitlement of the political elite. Indeed, the court must enforce the limits of power as enforced by our Constitution. My Lord, I have something I would like to put to you as an officer of this court. When public officers come before the court, don't they have a duty to be impartial and to actually give the court, to the best of their ability, the issues as they are? And to that extent, can the IEBC come to court to protest on the issue of quorum, knowing very well that they are not fully constituted, knowing that the steps to fully constitute them are under the way? Should they waste public funds, public resources, time and money to come and contest such an obvious point? Should the AG, who ought to have advised the executive and the government to replace the commissioners who resigned immediately, should they waste public resources coming to canvass this point before the court, or should they have considered and said the work is underway? Can the IEBC contest the issue that there is no referendum law, the IEBC and Parliament, yet there is a referendum law pending now before Parliament, meaning that they have already identified there is a gap and they are working to redress it? Yet we hear the Parliament and the Attorney General canvassing, not the Attorney General, but IEBC, canvassing this issue before the court. Is this prudent use of resources? What is the court's role in this? Is this a case where the court should reprimand those officers, those state officers, and even ask them to bear the costs? It is happening too often, where state officers take Kenyans who question as their enemy, instead of serving them equally with others. These are the questions that are before the court, and I dare say they demonstrate the impunity which permeates ranks of state officers, the executive, very much of government. We are asking the court to utilize that sword to slay the monster. Parliament delayed the appointment of those commissioners by not passing the law. Can they use their delay to come and ask the court to find otherwise? These are the questions we are asking. We urge the court to dismiss this appeal and to affirm the judgment of the High Court. I yield to my learned junior, Muthoni Nyuguto.
President of the Court, Your Lordships and Ladyships, I am Ms. Nyuguto Muthoni, and in the brief time that I've been given, I'd like to address in brief the issue of public participation, the remit of the Constitution with regards to amendments, with regards to Article 257, and briefly touch on the basic structure doctrine. I'll begin with public participation. And public participation itself.
Council, sorry.
Yes.
Now, when we gave you the opportunity to address us,
yes,
it was in respect to the criticism that was made of your role.
Yes.
Not in respect to arguments.
Yes.
Either supporting or against the appeals that are before court. Because for the rest of the amici, we left that to their written arguments. So the criticism you are given the opportunity to react to was that you were impartial. Those are the directions we gave.
Your Lordship, with your guidance, some of the issues that I am highlighting were also criticized. And these were the basis that the appellants used to come to the conclusion that we were partial. So I'd just like to highlight, please.
Please do so in your 10 minutes.
Okay. As I was saying, public participation itself is the essence of democracy because it broadens the constitutional agenda. Public participation itself legitimizes the Constitution. It allows people to be committed to their Constitution through the level of public participation that was involved in their making. A key critical issue that we raised is the deprivation of human rights and citizenship, which first manifests in the lack of public participation within constitutional amendment and making processes. And it was our view, which has been attacked, that authentic and effective public participation does not occur when a proponent or a promoter of an envisaged public initiative comes up with a problem, it formulates a solution to that problem, then goes ahead and invites the public to give in their input to this initiative. This public participation within this context is ineffective. It is conflicted. Why? Is because it happens too late in the process, after all the issues and all the agendas have been framed, and most of the decisions have already been arrived at. We submit that the BBI constitutional amendment process failed to reach this threshold of authentic, effective public participation. This is because our reasoning is that when it comes to constitutional amendment process, the rigor is not the same as constitutional making. You can find that within an amendment process, the proposers or the promoters have secured the bare minimum of the votes, even before bringing and tabling to the populace, to the people, what this initiative is about. This itself, as it happened with the BBI constitutional amendment process, kind of short circuits and leads to an outcome that is already predetermined. Your Ladyship, there's a real difference between going through an empty ritual of public participation. Public participation by itself should enable the people to have an effect on the outcome of that participation. This was the history, and this is what informed the Superior Court as captured in paragraph 414 to 426. This process of the BBI constitutional amendment process, from the above, therefore, is not effective participation, rather tokenism. The law enjoyer, as captured in paragraph 3 of our digest, will show that public participation ought to have been effected before the collection of signatures. This itself did not happen. And more critically, I'd like to bring to the attention of the court that in appropriate circumstances, courts have considered actions and their impact that limit public participation and requires that these actions are postponed until after elections, especially when we are gearing to an electioneering period. This is supported, of course, in the case of Consumer Federation of Kenya versus the Minister of Information and Communications, as captured in page 4 of our digest. We urge the court, in dismissing this appeal, to consider the critical constitutional moment that we are in. We seek to effect large changes that have not met the participation threshold right before an election.
Counsel,
yes.
Just a moment, please.
Yes.
You are saying we should consider critically the constitutional moment in which we are. Are you saying we are in a constitutional moment? Because that is an issue that has emerged from the record.
From the record and from our understanding is that the BBI amendment process seeks to usurp, seeks to change, seeks to replace the existing constitution. They have created an ideal, a situation that is not within the interest of the constitution. It seeks to usurp the constitution as it is and replace it right before an election.
Karen, please. Thank you.
And this is especially within the context that public and effective and authentic public participation has yet to be carried out. On the issue of constitutional nature and remit and power of amendment with regards to popular initiative, I will restrict my submission to these critical questions. When public officers and state officers promote a popular initiative bill or amendment, they pose a threat and they seek to dilute the content of Article 1 on our sovereignty. The exercise of our sovereignty, as under Article 1.2, is very clear. The people may either exercise their sovereignty power, either directly or through their democratically elected representatives. The key word here is either directly or. So there's no overlap, there's no interchange. The people, being the sovereign, have retained the question of amending their constitution within the popular initiative to control their own course within the constitution. There's no interdependence of those roles. So when a state officer or the president promotes a popular initiative, these questions arise. Whose interest are they articulating? Whose interest will be excluded? How are the views of the participants going to be aggregated? What is the degree of public participation? Who bears the cost, and what is the benefit of that participation? And why? Why should one particular popular initiative benefit from the backing of the state or the public officer while others have not? The answer to this question is the very reason why the roles of rulers and governed are distinguished in Article 1. Quickly on the basic structure, the question remains. It has not been answered. What is basic structure? Basic structure is inherent. It's juridical. It is not an invention of courts. What I mean is that it can only be discovered, but it cannot be invented by courts. The Superior Court had no obligation to create basic structure. It is inherent. Just like human rights, it can only be discovered, it can only be acknowledged, it can only be realized, but it cannot be created. However, it can be ignored, it can be violated. Therefore, it can be granted by the state. It cannot be granted by judiciary, executive, or parliament.
Can it evolve or be enhanced?
It may be enhanced, however, it exists. It's DNA. It is the theoretical foundation. Who is Muthoni Nyuguto? You can say she has limbs, she has legs, she's short, but it is my DNA that really identifies me. That is basic structure. And what you've not been told by the appellants is that they have admitted that the Kenyan 2010 Constitution has a basic structure. It has a core, which the AG had stated can be called or identified as basic structure. If you allow me, then how can courts discover this basic structure? It is through looking at all the collective provisions that account for the Constitution text, our history, and other non-legal considerations. Countries like ours with dark constitutional histories, as my learned senior Professor Dr. Muthoni stated, have put in judiciary to protect the basic structure of the Constitution. I see my timing is up, but I pray for 5 minutes to sum it up.
No, we'll not give you 5 minutes.
President, 2 minutes only.
Two then.
Yes, please. It can be discovered, but looking at all the collective provisions that provide for constitutional making processes. Essentially, it is looking at all the provisions of social contract between the people and the state. It is all the provisions that provide or give power for the control of government and the bureaucratic administration of the state. These are in terms of 4. The first is public participation. It allows citizens to discuss, to be involved in decision making before laws and constitutions are made. It is the equality of political actors, in that the people, the citizens, are treated as political equals with their elected rulers. And this is what happens in ballots. It is within the concept of universalism, reaching a decision that is common, it's for the common good of the people. It is on citizenship, which seeks to decentralize the power of decision making to the grassroots level. This is what we call devolution. To be sure, the High Court did find that basic structure of the 2010 Constitution exists and is informed by our unique Kenyan experience. As my lead counsel had said, the final report of the Constitutional Review Commission stated, and I'll be very brief, because this is in page 124 of our submissions within the AG's record, that how can we protect the Constitution from a similar fate? There's need to protect the Constitution from indiscriminate amendments. And I'll end by this. This constitutional amendment bill is the death of the Constitution by 1,000 cuts. And in upholding the Superior Court's decision, this court might help our Constitution escape another 70 or 74 deadly cuts to the Constitution.
Thank you,
Thank
Council.
you.
Thank you.